So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about the limits of the Americans with Disabilities Act and a special court case that kind of illustrates that point. This is from the Ninth Circuit, which is famously liberal. It was submitted on July 13th, 2023. It's Fabiola Ruff versus GlaxoSmithKline, and they took it to the district court. And it's important to understand what the Americans with Disabilities Act is and what it is not. The Americans with Disabilities Act is very impressive from a comparative perspective, right? So disabled rights are in the United States, I would argue, some of the best in the world. And if you've ever traveled abroad, it's, for example, quite difficult to travel with a wheelchair in most nations because they don't have the protections that the United States has. But there are limitations to the law, and we'll talk about it here. So, in this court case, the plaintiff first claim was that the GlaxoSmithKline failed to accommodate her depression and anxiety because GSK, GlaxoSmithKline, did not transfer her to a position in which she would have no contact with a particular coworker with whom she had a stressful relationship. Now, first, let's acknowledge depression and anxiety under the ADA's definition is a disability. And that's important to understand and acknowledge that this is a true disability in these circumstances. The ADA defines an individual with a disability as a person who has a physical or mental impairment that substantially limits one or more major life activities, a person who has a history or record of such an impairment, or a person who is perceived by others as having such an impairment, but doesn't. And that's kind of interesting. There are quite a few court cases where a person is perceived to have a disability, does not, they still have the protections. And so it's about whether or not they're limited by one or more major life activity. A major life activity is defined as, or it has examples such as breathing, walking, talking, hearing, sleeping, caring for oneself, performing manual tasks, and working. So we have to acknowledge first that this claimant does have a disability, or at least appears to have a disability. So Ruff, the plaintiff, said on the appeal that her accommodation was to be reassigned to a position that limited contact with the coworker. And this is where it gets a little difficult at the beginning, right? So the company is not required to reassign someone to a position at all. I mean, the plaintiff can absolutely apply for jobs, but the ADA is to help people do their job effectively and efficiently. So the idea that do their jobs effectively and efficiently. So the idea that they're going to accommodate by giving them a different job, that's not the nature of the ADA, and it's not the intention. Now, you can help people out by having them apply and so forth, but that's not an accommodation. An accommodation is helping you do your job successfully. The court assumed that it could be an accommodation at some point, but it's not a reasonable accommodation here, which is important for the purposes of ADA. Then Ruff further claimed that she had to resign because GlaxoSmithKline failed to provide a reasonable accommodation, that allowed her to return to work. And that's not true, at least not from the court's eyes. The defendant did not, defendant being GlaxoSmithKline, did not fail to provide reasonable accommodation. And ultimately, the court argued further, and this is kind of key to this, right, is that the GlaxoSmithKline didn't ask her to resign. It wasn't sort of a constructive discharge, what it sounds like she's arguing. The person ended their short-term disability because they took another job with double the pay. In addition, the plaintiff, continued to collect disability benefits. I assume short-term disability or long-term disability, one of the two, not federal or state aid. Continued to collect disability benefits from GlaxoSmithKline after she began working at her new place of employment, which is pretty impressive and a little bit infuriating. A lot of companies do go through this. This is sort of the nature of the beast when you get involved in employment. But I have to call that out. Ultimately, cases like these are pretty common. Cases where there's an assumption of a unilateral and ultimate accommodation right that simply doesn't exist and frankly can't exist in the workplace, requiring the company to move you where, there's no discussion of whether or not the company could, whether or not they had a position, things like that. I am all about personally getting people back to work if we have a job for them. but we can't simply create jobs out of nowhere, and we also can't force people into, or give people jobs just for the sake of it. We have to accommodate the jobs that they currently do and help them be successful at them, and that's really sort of the crux and where I feel most pride as an HR person is when you see something like that. Let me know what you think about this case in the comments down below. I think it's an interesting one. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.